On my mic, thank you. I'm gonna, if you join us in the pledge, and Daley's gonna lead us.
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Well, thank you all for coming. Are you ready to go?
I am.
All right. We're gonna open up the hearing on the, where's the number? There it is, amendment number 1499S. And I'm gonna call on Senator Perkins Folk and introduce it.
Sure. Do you want me to go up there, Chair? Doesn't matter.
It's up to you, I don't care. Probably be better if you did.
Yeah. Good morning, Chairman and members of my fellow members of EDNA. Happy to be with you this morning to present Amendment 1499, which I had drafted originally to be changes that we heard in the hearing for House Bill 655. It obviously now has become an amendment to HB 532, but still addresses the same issues, which are those that were raised about HB 655 when it was brought over by the House, from the House. So I think what may be the easiest is if I kind of walk the committee through page by page so that everybody here knows, sort of what the changes are and what we're addressing. So on the bottom of page 1 and at the top of page 2, we've added, or I have added, definitions of allegation, complaint, and license. And I did this in response to something that will come up a little bit later, but it's part of making sure that procedurally we're just protecting all of our professional licensees, as they face allegations or complaint of professional misconduct. I have received some feedback that the definitions of allegation and complaint may be, a level that we don't need to be specific on in this amendment. So I'm certainly open to hearing feedback on that today, but I think that may be a further change we want to make. If we go to page 3, line 30, I just changed the name of the Assessing Certification Board under RSA 310C to be the correct name. I'm actually on that board, so just wanted to make sure that we reflected the right name. All right, if we go through. Okay, so not all these changes are highlighted. If we move to page 7, in line 2, we wanted to make sure that, I believe this was physician's assistants were included in telehealth, and so we added RSA 328D. If we go, then on that same page, line 9 and 10, I just added that out-of-state healthcare professionals could also be licensed pursuant to a licensing compact or endorsement. So that's a concept we're trying to incorporate across OPLC. Okay, if we go to page 8, starting on line 26, there's just a few changes I made here that mostly show up on page 9. And these are the changes I was talking about. These are probably the most substantive changes in here, but essentially just to make sure that all of our licensees when a complaint or allegation is received by the office at OPLC, that we've made clear sort of how the procedure works in terms of what the staff is handling, when the complaint is referred to the board. And then all the procedure and enforcement that the board would undertake is being addressed still in the House process. So this is just for the staff actions. And I've just added in a few simple things. I'll point them out if it's helpful. But on page 9, on line 6, I just added in language, the office shall determine whether the allegation states a claim of professional misconduct on its face. On line 7, if the office determines that the allegation does not state a claim, was my addition, it shall make a recommendation to the board for dismissal. On line 9, the board shall review the office's recommendation and dismiss if it agrees with the office's recommendation. And so I don't know if it's helpful to go through every one of these lines, but essentially, there's some changes that show up throughout this section. Should I highlight each of them, or?
It's probably a good idea.
Good idea, okay.
There's a lot
All
of
right.
changes in here.
Sure. Okay, so page 9, line 13, I added upon direction by the board, just to make the relationship between the board and the staff clear. And then I also added little in Romanet B, upon confirmation, and it reads that a written complaint alleging misconduct should be investigated. I added in the language except as provided for the Board of Accountancy, which is a conversation, we can have as a committee, but we heard in testimony that there's the Uniform Accountancy Act in that field, and so there's just extensive disciplinary procedures that they already have. In line 25, we heard that the boards wanted to make sure that they had some input on the experts that were retained, so I just added in approved by the appropriate board. On line 28, there's, it talks about conducting inspections in places of business of a profession regulated under the office, which may include only, and this was some feedback we should, the portion of a residence where the professional equipment is located, because we heard feedback that some inspections were taking place in residential areas, so it's just a protection there. All right, continue my very exciting presentation here. I'm just trying to see where else we've got some annotations. Okay. All right, I think the next change may be sorry, Chair, just trying to locate this.
All right, take your time.
Okay. So I know there's a change on the top of page 18, line 2. And this was just some feedback we received from the electricians. This is an appeal procedure which goes directly to the Supreme Court, but there's a statute that if it's sort of a building code level decision, that there's a separate procedure, appeal procedure to the Superior Court. So we just wanted to capture that. And then all right, what I'm having trouble locating in 1499 is that one other change that we heard about in the hearing. Here it is. I just found it. On page 17, just to take you backwards, line 26, we did hear that there was concern if OPLC was going to investigate that there needed to be sort of a cap on investigative fees. And so in the hearing, we talked to Director Courtney about that, and she said it might have just been inadvertently left out. So I inserted a cap up to 10,000 for each investigation. All right, and then just two more changes as we get to the end. On page 22, lines 33, 35, and then page 23, lines 1, 3, 5. I've added in these repeals, but only because OLS brought to my attention that these repeals were needed to just sort of do some cleanup. At the beginning of the bill, we name all the boards that are subject now to OPLC as restructured by the statute. And so the repeals that we're making in section 27 are just administrative cleanup to sort of reflect that change. And then I think that's it, except I just did want to point out before I open it up to questions, there was some comments on examination. There were some comments on what shows up in 1499 as page 4, line 30. Whether this sort of question of objective standards made sense. So I think that's something we still need to hear some feedback on. I did not make any changes to that language, but it was an issue that was raised. In considering whether to make changes to that, I did find out that all the existing rules of OPLC are going to be grandfathered by HB 655, and so there are some protections in place there. But if there's still concerns that remain, we may just want to hear those today. And that is my thrilling presentation, Chair.
Well, I have to do the next one, so I'm thinking you did a better job than I'm going to already. Any questions from the committee? Sarah Carson.
Thank you. First of all, Senator Perkins Coca, you did a great job.
Thanks.
I know what it's like, and it's wordsmithing more than anything else. I do have a question on page 18,
Yep.
Lines 1 and 2. Why the Supreme Court versus Superior Court?
Yeah, I have the same question for you, and it might make my change unnecessary, but I know that that's how it came over to us from the House. So I don't know if there's a specific procedure for appeals under 541. I didn't get to investigate that specific issue.
Okay. Well, when Ms. Courtney comes up and speaks, well, I'll ask the question. I was just curious because I would think that you would go to Superior Court first. But since it is an appeal, you go to an appellate court. So I just didn't know if you had any feedback from the Supreme Court on that at all.
I do not.
Okay.
I think we'll get an answer to
We'll
that
get
as
an
we go
answer.
forward. I know Representative McGuire may have the answer as well, so we'll get an answer to that as we go on. We can make a note to ask that.
Thank you.
Further questions?
If I may, before I step down, Chair, I did just want to mention, I had a conversation with OPLC yesterday about the text of this amendment. They did have a few changes that maybe they'll speak to today, a few that I thought we could accommodate, but I didn't redraft anything for today because I figured we would hear other feedback, so perhaps they can be incorporated.
Well, for the benefit of everyone, the reason
Yep.
I'm doing it this way is I'm holding these two non-germane amendment hearings today, and we will not be accepting them until next week because I'm aware we're going to need to make some changes and corrections and deletions and additions and things that it is a working document right now. So I just, for the benefit of everyone, that's why we're here and doing it this way.
Okay.
Thank you.
Thank you very much.
you.
Good sign up here.
Carol has her hand up.
Representative McGuire, you're not signed up on here to speak, at least I haven't found you yet. Do you want to speak next? Okay.
Good morning, Mr. Chair, Senators. I'm Carol McGuire, representing Merrimack District 27, and also the Chair of House ED&A. I have an answer for Senator Carson. That section of law allows the electricians board, an electrician, to appeal a decision to the Building Code Review Board, particularly in the case of the interpretation of a building code, because it's felt by a lot of people that it'd be easier to explain it to people who understand the building code when there's a question of interpretation than to bring it to court. It's specifically an appeal on the electricians board to the Building Code Review Board. And it might be clearer if you copied the text of that section of law, but that's what it is.
And did you have an answer on the Supreme Court question, why it was appealed to the Supreme Court?
No?
Okay.
Oh, okay, if I may.
Yes,
Mr. Chair.
absolutely.
Thank you. Thank you, Representative. Because I just thought it was strange that it would go to the Superior, but the Superior Court is an appellate court. It just seems like it's a high bar, the Supreme Court. Because I'm looking at the section, it's 310.14 rehearing appeals, but I don't see any reference in there for the electricians, because it seems like that is a different process than for the other boards.
That's only an appeal.
Mm-hmm.
And if they do a rehearing before the board and decide that it's a question of interpretation of building codes, they can go to the Building Code Review Board. Otherwise, they go from the licensing board to the Supreme Court, according to the bill.
Okay.
I'm afraid I don't know why they don't go to Superior Court first.
Okay, if I may, I don't see a reference to, specifically to the electricians board unless 310.14 addresses them directly. Do you know offhand?
Well, we can look up at the front statute here. The Board of Electricians are Electricians Board is 319C.
Okay. We need to, okay, thank you. I'm gonna,
Okay.
we have our statutes back here. I'm gonna
Yes.
take a look, because if it is an appeal process that's different from others, I'd hate to have it get caught up, that it probably needs to be
They're
separate.
probably more familiar with that than I am,
Yeah.
so. The other I have two other comments. The first one is that on page 1, the definition of board was left out, and I think that's rather important.
And where was that again?
Bottom of page 1, it goes from allegation to complaint, skipping over board.
I've got that, yep.
All right.
Okay, and as a personal comment, I'd say that getting this amendment in this format makes it extremely difficult for us to figure out what's going on and what's being changed and what the references are. So I would if you are making corrections and additions and deletions, I'd appreciate your deleting the non-changed sections of statute.
Me too.
It's your amendment, Senator.
All right.
So, and in general, I'd say that most of there isn't anything that appears to be blatantly wrong from what I could tell, but I'm sure that some of the people behind me will have more specific data to bring their concerns up.
Questions? Seeing none, thank you.
Okay.
Thank you.
The reference, oh, okay. I think probably at this point in time, it would be good to bring Director Courtney and Attorney Osterhout up and have them go through some of these technical questions that we have. what I may do, if the two of you are willing, is after we have everyone else testify, I might bring you back up again, because there may be other things that the committee needs to ask you.
Certainly. Thank you, Mr. Chair, members of the committee. For the record, Lindsay Courtney, Executive Director, OPLC.
Douglas Osterhout, General Counsel, OPLC.
Thank you, Senator Perkins Quokka, for bringing the amendment forward. There are several changes that we think are necessary, cleanup changes, if you will, to House Bill 655. The first being to include the PAs and the telehealth. That clearly was an oversight, I think, from last year. As well as making sure that we're not transferring the wrong assessing board from DRA over to OPLC. So that change to 310A is certainly necessary. We are also supportive of.
Director, is that in this amendment?
Yep. Correct.
Okay, where is it in?
Oh, sorry.
It's okay.
It just moved so fast. Yeah, so if you look at the telehealth provision, which I think is on page, let's see, 7,
All right.
there is an addition, I think it's 328B, are the physician assistants. So previously, they have not been included in this comparable provision in our existing statute. And physician assistants are able to practice telehealth without supervision. So we are supportive of that change.
Okay.
If you look at page, I think it's 3, assessing certification board under RSA 310C, it's line 30. In 655, it actually references the assessing standards board, which is a different board within the Department of Revenue. And that, I believe, was an oversight because they are well attached to DRA, and we have no desire to bring them over, and I think DRA would like to keep them. So we are supportive of that change. The other change that we are supportive of is really making the language clear on page 9.
So, Director, if I can back you up for 1 second.
Of course.
I'm not clear on what you want us to do with the assessing certification.
Nothing. We just wanted to express our support of the way it's worded.
Okay, perfect. All right.
Sorry, I'm not being clear this morning, Senator.
There's a lot here in my head.
So far, we have 2 thumbs up.
Yes.
Okay.
We do have a couple of concerns, which I'll get to, but I wanted to address that we support the change in language on page 9. In 655, it talks about the fact that the office needs to determine whether the claim is viable. In this amendment, it uses the language on page 5, the office shall determine whether the allegation states a claim of misconduct on its face. I think that's clearer to anybody reading this statute what exactly we are required to do. So we are supportive of that change in the language. And then there are a few concerns that we have. The first one that I wanted to address was the allocation versus complaint. The definitions that were included on page 1. So my understanding is that this is a current process, allegation versus complaint, within the Board of Psychology, the Board of Mental Health Practice. Largely, other than calling information received initially an allegation and then a complaint that is formally determined to proceed to a formal investigation. Other than that, our process for the Psychology Board, the Board of Mental Health Practice, and all of our other boards is essentially the same, other than the language. My understanding is that it's been very important to stakeholders interested in the Board of Psychology in particular to maintain this separation or this distinction between allegation versus complaint. From our perspective, after talking with stakeholders, we do not believe that is necessary, and we actually think that the language is somewhat confusing because complaint includes the word alleged, in the definition of complaint. So it's confusing to us as to what the distinction would really be between complaint and allegation. I think I understand the primary concern to be this, which is that professionals who have professional liability insurance have an obligation pursuant to their contract with their carrier to report certain things, whether it be allegations, complaints, claims, whatever it may be. And this is obviously to determine whether the carrier wants to maintain coverage and what the amount of the coverage should be and what the charge should be for that coverage. Psychologists and licensees under the Board of Mental Health Practice are likely to receive complaints, sometimes that lack merit, by virtue of the work that they do. So the concern, I think, is that by receiving a complaint that lacks merit, if it's called a complaint, they would be required to report that to the carrier. We don't view it that way. We view that obligation as being dictated by the terms of the contract between the carrier and the licensee, and not what you call the information that the office receives. But we would suggest that one way to address that concern, other than dictating the terminology we use in the office, would be to essentially not notify the licensee of the complaint, allegation, concern, until such time as the board has determined, or the office has determined, that it does state a claim of professional misconduct. That's the way lawyers do it. Lawyers will make that initial assessment. The ADO will make that initial assessment prior to sending out a letter to the licensee. And we've looked at the contract between, or sample contracts between licensees and carriers in the psychology realm. And as long as one has no reason to know that there's a complaint out there, they have no obligation to report it. So we think that would be the better approach if the committee felt that we needed to address this. But on its face, allegation versus complaint is confusing, and we don't think it's warranted in this context.
Can I ask a question?
Sure, go ahead.
Thank you, Mr. Chair. If you'll take a question about
Certainly.
that. I'm following you, that I'm following that between, there are 2 pages of different kind of licensees, so that the terminology allegation and complaint is applied differently across the board here. And you're specifically talking about psychology, right? Is that, am I following you so far?
Correct, Senator.
Yeah.
So I referenced psychology because I know that's the genesis for
Okay.
the desire to have this distinction. It's
But there are more?
No, my understanding is no other board, other than psychology and perhaps the Board of Mental Health Practice, has requested this distinction.
Okay, so if a consumer were to make a complaint, right, to the board of whatever, on anybody on pages 2 and 3,
Correct.
and they also CC that complaint to the provider, are you telling me that the provider, upon receipt of the complaint, now that they know that there's a complaint, are obligated to inform their carrier that there is a complaint? But if that person, if that consumer only brought that complaint forward to the board, and the provider were unaware, and it wasn't CC'd to them, like the consumer didn't like send it to literally everybody, then they can just keep going about their business until they are subsequently informed. Like, I'm missing how that works.
So I think my point is that I don't think we can dictate in enforcement procedures what the contract requires.
Right.
And I think that's what historically it's been unclear in the Board of Psychology statute in particular, because a carrier can always say, I'm only willing to contract with you if you are willing to report X, Y, and Z to me. And that is an agreement that they agree to. What I meant, and I apologize, this wasn't clear, is that we have reviewed sample contracts, and all of them contain this requirement that you report X, Y, and Z to the best of your knowledge. So clearly, if you're not aware, there's no obligation to report under those sample contracts that we reviewed. I think we could make a change, which is not really making a change in our existing procedures, but to make it clear that a complaint is docketed, if you will, which is what lawyers use the term, if it's deemed viable or it does state a claim on its face. That would make it clear as to what the reporting obligation is. I'll give you an example.
Thank you.
A complaint that we have received in the past is the Jell-O complaint. The Jell-O was terrible, and my doctor is a terrible doctor because we don't like the Jell-O. That is a complaint that we've received. Now, every reasonable person would not believe that they have a reporting obligation because that is not a meritorious complaint on its face, meaning that if we take everything that this person said is true, that the Jell-O was terrible, that in and of itself is not professional misconduct. And so we're not going to docket that. We're not going to move forward with a formal investigation. And the licensee receives a letter, it's been dismissed. Because it's not been formally investigated, I think they could say that's not reportable, but it would have to be dictated by the terms of their contract between the carrier. And that's why I think it's not, we don't want to get in the business of creating legislation around what we think could be in a contract and what couldn't be in a contract. This legislation should really be concerning enforcement procedures and enforcement procedures only, and not professional liability issues.
So what's your suggestion for defining allegation and complaint to make it more broad so that, I mean, it has to be defined because it's applicable. I mean, this is a very broad piece of legislation now, and this was always the difficulty, is addressing the minutia of specialities in a broad piece of legislation. So, any suggestions?
I don't think there should be a distinction at all. I joke around in my office. It doesn't matter what you call it. You can call it a banana. It's information received that somebody has committed misconduct. That is what a complaint is. It's the same thing as an allegation. It's the same thing as a claim. It's the same thing as a charge. It doesn't really matter what you call it, because once we know that there is this information lending one to think that professional misconduct may have occurred, we have a duty to look into it.
Okay, so you're saying combine A and B.
Correct.
And okay, thank you. Okay.
All right,
So
let's keep moving.
allegations / complaints / notification, these are all things that would describe a consumer reaching out to OPLC or a specific board
Right.
with an issue they're having with a provider.
Right.
All right, so you're looking to combine that. All right, I'm sorry, it just took me a while to get there.
No, I appreciate your questions. So moving on to page 8, I want to address briefly the change to existing law. It's line 4. Under the proposed amendment, licenses shall be valid from the date of issuance and for the term stated on the license. The concern I have is that some practice acts do not have statutory authority for a term on the license. And so without statutory authority, it could leave some licenses to be valid in perpetuity. So that's one concern. The second concern is, due to a statutory change last year, we transitioned everybody moving forward to 2-year licenses. I think this is intended to allow licenses to essentially go back to either having 1-year or 3-year licenses. From an implementation standpoint, that's, it's burdensome because we already switched everybody over. a couple months ago to a 2-year time frame. Additionally, from a fiscal standpoint, it's problematic because we are on a biennium. Our budget is governed by what we project in a biennium, and 3-year license types in particular render it very difficult for us to project the amount of revenue that we are going to receive. So we think the best practice is to have everybody have a 2-year license. We would not object or oppose to having a carve out specific to apprenticeships only, because those are in a unique category. That said, some apprenticeships, I believe, are 2 years, and some boards do like the 2-year time frame. So I don't think it's standard across the board. But bottom line is, I think that there should be a specific time frame in statute to avoid those licenses in perpetuity. And then turning to page 9, and I apologize, I'm trying to keep this brief, but I'm not succeeding. Our primary concern here on page 9 is that it appears to reverse what 655 does, in the sense that 655 essentially transferred investigative authority directly to the office so that the office doesn't have to seek approval or be directed by the board. The addition of the language on page 9, line 13, notwithstanding any other law to the contrary, upon direction by the board, we would interpret that to require the board to direct an investigation and not allow us to investigate absent that direction. The concern here is twofold. First, being that it could slow down investigations, particularly for those boards that don't meet on a regular basis. And then secondly, there's a concern about the appearance of the adjudicating body having too much information about an investigation. And I think that concern is legitimate. In order for somebody to feel that they've been heard and that their complaint has been properly adjudicated, they need to make sure that the tribunal is impartial, and this creates a situation, or could create a situation, where that could be called into question. And then actually,
Director,
yes,
do you mind if
certainly.
I have to ask you a question. So would you believe, this is just a matter I welcome feedback on from anyone that's here today, because I certainly hear Director Courtney's points, but I just want to understand, from a practical perspective, if there are concerns with us making that change. So, thank you.
Certainly.
Senator Carson? Yeah.
While you're answering questions and we're on this section, I'm looking at on page 9, lines 27 and 28, which would give you the authority to conduct inspections. But what I find troubling is the language on line 28, which it says, which may include only the portion of a residence where professional equipment is located.
Senator, I think that's in the next amendment that we address this.
Okay,
If I'm not mistaken, I believe we're addressing that in the second amendment.
okay, all right, that's fine. I'll wait. I've got to go over to the house anyway.
Okay.
The other concern with respect to this paragraph was that it exempts the Board of Accountancy. The Board of Accountancy statute, and I forget the RSA off the top of my head, essentially authorizes what I would consider to be fishing expeditions. And we're not aware of any other specific disciplinary procedures with respect to the Board of Accountancy. I think what we heard at testimony was that the certification, the national certification process and our process has been conflated, both in the licensing standpoint and with respect to investigative and disciplinary procedures. And this is probably because the Board of Accountancy in New Hampshire has essentially outsourced its licensing function to the national certification body. And so certainly there are disciplinary procedures that apply to national certifications. That is not the same thing as state licensure disciplinary proceedings. And we're not aware of any reason why we should exempt Board of Accountancy. And our primary concern is that by carving out certain boards, you will see legislation here next year asking for 50 additional carve-outs, because it's able to articulate why they're unique and need their own procedure, which is exactly the opposite of what I think OPLC is trying to do. So so we had some concerns about that. And then I just want to make sure, Douglas, did you want to clean anything up that I misstated? Okay, with that, I'd be happy to answer any additional questions.
Turn back on, sorry. Questions from the committee? I'm sure there's going to be many, so
Certainly,
I think what we'll do is, if you want to, you plan to stay?
yes.
Here, okay. We'll take the rest of the testimony and we may bring you back because I'm certain there'll be more questions, Janet.
Happy to. Thank you. Appreciate your time.
Sure. I think we'll bring up Elizabeth Eaton next, since we've been on the Board of Psychology. And Dr. Warner, too? Okay.
Yes, thank you. My testimony almost entirely is in conjunction with Dr. Warner's.
That's totally fine. We're being a little less formal today.
I appreciate
I know
it.
there's a lot in here. Thank you for coming.
Yes, thank you so much for having this hearing and for bringing forward this amendment. I'm Dr. Deborah Warner. I'm here representing the Board of Psychologists, and also I will speak independently after I'm done with the board message to you. I would like to refer you to the handout that I sent ahead, and that is, where is it now? Gotta get all my, I think this fell off of this. Here we go. Yes. So I'd like to give you a little tiny story of the history of this board and how this business began. Is that most of the boards, the 54 boards, were actually constructed in the last century. And during that time, having a license was viewed as a privilege. And so any adjudications and handling of complaints or application issues was not considered subject to the Constitution issues and rights, but more in terms of being consistent and fair because it was administered by the state. And then about a dozen years ago, the mental health and psychology people got together and they brought forward objections to the manner in which these things were done. And the legislature went along with the concerns that there was a need for due process and things to be handled in terms of rights under constitutional law. And so what you have is you have two boards, psychology and mental health, who have modern provisions in their practice codes that include due process and also protecting patient rights as well, whereas those things are not in the other 52 boards. And so you have this sort of difficult handling for OPLC as they're trying to merge things together and have a unified method of handling things. So I am with the psychology board, and actually previously I was on the mental health board. So I've got experience with both boards. I will say to you, I forgot my hat, but you know my hat, I wear the hat. As a member of the Board of Psychologists, I'm authorized to present to you their concerns, and you've already seen in the statement that was emailed to you from the Board of Psychologists on April 7th that has a very long listing of exact edits that would be desirable and would preserve these due process rights that are in our codes, in our statutes, into the new fundamental statute that's being under consideration in 310. So I'd like to say I've analyzed in this handout that you have, I've analyzed the current amendment with regard to that communication you received from the board, and this is the result of that analysis. I will now take off the hat so that I can extemporaneously explain it, because of course every word from the board needs to be approved by the board. But now I'll talk to you as psychologist and someone with a lot of expertise on this topic. So I'd like to say I'm delighted with this amendment and that you have captured the allegation versus complaint issue and put it into this section. I think it's very, very good. It's very important, as you've heard from many licensees, that it's just unfair that you could lose your membership in a hospital medical staff or insurance or a panel, or a lot of economic and professional standing can be lost by just a small complaint that might involve that you didn't have the right Kleenex, or you gave somebody the wrong code number for their chart, or things like this could happen. And then you wouldn't want to ruin somebody's entire business because of things like that. And so in the statutes previously, the allegation versus complaint bifurcation came about. It has been working for these boards for these 10 and 12 years, and that's a very helpful process. Now, Executive Director Courtney did say something about interfering with a contract. And actually, that is how contracts change, is that the state changes what's permitted. You're not permitted to ask somebody's race or weight or things like that in their application. And so those things change. And these will change with time with this thing in place. It is certainly up to the licensee to adhere to their agreements and contracts. But that's not a reason not to put it in. It is just going to be a little bit more cumbersome, but it is fair and it is right. And so I'd like to call your attention to, on my outline, the bifurcation of allegation versus complaint. This intent can be better fulfilled if certain provisions are also put in place. If you see in the scrolling down in my long handout with the details of what should be put in there, under 310:9, which is investigations and complaints, there are about 8 different things, let's see, A through G, that would be proper to put in order to flesh that out and make the actions appropriate in terms of due process in general, as well it also upholds the distinction between the allegation and the complaint. In section 310:9A, further back in your document than that, is a little section to put in to clarify the protected status of the allegation and how that comes about and how that is managed. Those things will actually put together and fulfill the intent of separating the allegation from the complaint in there. We have public interests. The sharing of the allegation immediately is actually important with the licensee because, especially in all of the licenses, then that provider can make sure they're meeting the needs of their customers. But in the mental health field, it's particularly important that if somebody is making a complaint, that you can be sensitive to their needs. And in fact, sometimes if somebody is decompensating psychologically, it can be an indicator that things are getting very, very far out of hand. And that's public safety, that's their safety, and it even can be the psychologist's safety. So those are important to do. In terms of Executive Director Courtney's comment that, well, just don't tell them and they'll never know, you get told later that it was dismissed, and now you know. You're going to have to report it anyway. It can still have that same damaging effect on your business and your career. Medical records privacy is in this bill already, and it was already in the 310. It's also in here in your amendment. It's included, but there was a suggestion along the way that it would be, after tried for these dozen years, that it would be found appropriate to spread it to the other health professions. Just bringing that up, that is something that certainly would be up to you. But making sure that the public right to privacy is known, that the state cannot take their medical records without their knowledge or consent. Another due process piece, if you look on page 2 of my handout, the summary of investigation is a very important product of the investigation. When you've completed an investigation, when the department does, then there's a report given to the board that has the legal analysis and a summary of all the evidence that has been gathered, both in favor and against the claim. And then you also have the same report with all the legal analysis redacted from it, and that goes to the licensee at the point before they might need to accept a punishment in a settlement agreement. That was considered a very important thing in the modernization of these two boards' laws, and it was difficult to get the attorneys involved in supporting it, but it did come forth, and it's very much appreciated, and it's not hard to do, and it does make sense. We're all kind of familiar with, having watched television law programs, that there's this thing called discovery, where before you all do important business, you get to see what the other person has in their hands, and that is that same thing in this venue. The other things are housekeeping items, cost of investigations. I think that should probably be done by reference instead of repeating the same thing from 332G:11. And so I think that would help the consistency of the law that way. And in also housekeeping, the misconduct offenses list, which I put in as 310:10A, misconduct, is completely missing in 310. It's also missing, and it hasn't been put in. And in fact, the boards rely on that quite a bit. It's in almost every official order of complaint and formal investigation. Well, what are you charging them with? You need the charges. Those should be in there. I just simply copied it from other board statutes, and I put them into my suggestion list. Under sanctions 310:12, there are a number of items that are missing that are in current use and are in various statutes already. And so I place them into this edit list. And that, let me see, there's a couple of points. Requiring the board to structure the investigation and make that initial authorization for an investigation is currently what's the purpose and way that investigations are done. And in fact, the board is the agency of that, and the people on the board are authorized by governor and council and for their expertise in the profession, and it would be up to them to define, well, what was wrong and what should be investigated. I am concerned with the way that 310 was originally worded, in that it really was a setup for a fishing expedition, and that was not good law, or that's not New Hampshire. That's not what we do. Let me look at my other little tiny notes from this. I did, thank you.
All right, thank you, Dr. Warner. Is there any questions? You've given us a lot of things to chew on and think about here, and appreciate certainly all your work and suggestions. Any questions? All right. Did you want to testify too?
Certainly. Elizabeth Eaton. I'm board counsel to the Board of Psychology, and I wanted to reiterate one point. Dr. Warner was very thorough. One point that is, it's been consistently missing from all versions of 655 that I've seen is the misconduct offenses list. It is important that that is in statute. Boards do rely on that when they are referring to investigation. They cite the misconduct when they are holding their adjudicative hearings and when they create settlement agreements, when they have final orders.
Okay, I made a note of that.
Okay, and that concludes my testimony for the Board of Psychology, and I did note that I will have 1 point for the Board of Veterinary Medicine, so you're all set if you want.
I would be very happy to talk with anybody or work with you on independently on any of these details.
Well, thank you, Dr. Warner. We have your contact info, I think, on here.
Yes, thank you.
Okay, thank you.
So very briefly, for the Board of Veterinary Medicine, again, we're going to page 7, the telehealth portion. The Board of Veterinary Medicine would like to be included in the list of professions permitted to conduct telehealth. There chapter is RSA 332B, if they could be considered for inclusion there.
All right. 332B, okay. Questions from the committee? Seeing none, we thank you.
Thank you.
All right, I think we'll switch over to the electricians. Steve, you want to come up?
Good morning, Mr. Chairman, and committee members. Thank you for your time. I'd like to just hang this out if I could. Oh, we're talking. So, and there's been a lot of changes going on, and we hope that going to working on addressing some of the concerns. We had a couple of things we were looking to see if we could clarify. There was some suggestions made from Senator Quokka, and we appreciate that. But on the handout that we're handing out right now has to do with page 9. Line 28, and this is something that Senator Carson had brought up earlier, is we have concern that they're allowed to conduct investigations, and if you look at line 24, it talks about the investigations by the executive director, and it's allowing them to go into your place of business, and we just feel that if you have a business in your home, that should be excluded without following proper legal procedure for a warrant or subpoena, not just coming in because they do an investigation. If you're doing one for, if I have a public facility, commercial facility that's open to the public, then we understand they should be able to come in just as well. But don't feel that we should be giving the OPLC the authority to walk into anybody's house. And in the attempt that was made by Senator, I appreciate, but it still allows them to walk through my house to get to that office, which we just feel is, again, not that they can't go there, but they have subpoena power for records and everything else below. We just feel that that's a little bit past the live free or die in the state we live in. So we offer that suggestion and recommendation as far as an amendment to that. So they have to live in the abode, and their office is there, and it's where they reside as well, that they wouldn't be able to go in without following other proper procedures.
Well, thank you, Steve. I remember we had talked about it, and I was thinking it was in the other amendment, but it was, I remember now that you were bringing the language, so thank you to clarify Senator Carson's earlier question. There's a few moving pieces here.
Yeah, there's a lot going on. There's a lot going on. We also, it was discussed a little bit earlier by Executive Director Lindsay that the 2-year/1 year license, we've had some discussions with them about it. Our apprenticeship happens to be that it's 1 year and you have to show proof of schooling. So it would be important to us that they could do that. While we totally understand trying to be consistent with the 2-year, to kind of say it's more of a bother to change everything. I mean, we're going to get all this new software. We're spending all this money. We've been doing it for 37 years. I think we can handle a 1 year and a 2 year. It's very important in our profession because they have to show that they're going to school, and it's what helps us with our reciprocity to other states, which we're trying to increase. So we would hope that that would be something she mentioned. It was on, I think it was on page 8, line 4, that she talked about some concerns with that. They're trying to work it out. We'd just like to throw out there that if it could be set up for apprentices, being 1 year, that would be very helpful.
May I ask a question?
Certainly. Go ahead,
Yes.
Senator Ursula.
Before you move on from that, so there's reciprocity, there's an interstate compact, and within that, students who are moving towards their electrician's license have to fulfill a full year academic requirement? Is that what you're saying? That they are also able to practice alongside?
Yes, so they receive their.
Yeah,
If I-
like flesh it out for
Yep.
me.
If I
I
understand
don't
the-
have the institutional knowledge that you do, so you're coming in here and I'm like crawling up, so.
No problem, be glad to. It also applies for other professions, mechanical and stuff. They may have a 2-year, but you basically, when you get your apprentice card, it's a registration as an apprentice. You can go and apply today, and if you fill everything out, get it very quickly. And then you have to do on-the-job training as well as schooling. So before you can renew, whether you consider it the first renewal or second, but that second time when you go to renew, they have to show proof of enrollment in schooling and continue to do that each year. So their registration card is only good for 1 year for that purpose. Because it helps raise the bar for us as far as the level of it, making sure, like Massachusetts doesn't have any tracking of their apprentices or any of that. So we recently had an issue in front of the board with 5 apprentices working on a job from Massachusetts with no license, so. Those are the things that, it helps raise the bar for New Hampshire for us, and we would like to keep it that way if we could.
So you, after the first year, if the educational component is not complete, then you're saying they renew for an additional 1 year?
You have to be enrolled in school, the whole
Right,
process.
if they're not done with the educational process,
Right, it's
then
4 years.
you kept every year that you're in school, you keep renewing for the 1 year.
Correct. So it shows that you're continuing on the path of, it requires 600 hours of schooling and 8,000 hours of training. It's all usually done in a 4-year period. 150 hours of schooling each year, along with 2,000 hours of OJT. So that process brings them and educates them very well and helps. If they're not gonna go to school and they're just there, then they're not interested in being in the trade. They're just,
And that can't be accomplished in a 2-year increment, because they're still going to school, right?
but they would renew for the second year without showing proof of schooling. So they could not go to school that year, and then the second year they come back and renew, now they show it again, they skip another year. They could actually skip a year because they don't have to show proof before renewing that card. Till 2 years, which is an issue as far as,
Okay.
especially our inspectors. It creates an issue for our inspectors on the field, because they go and they might check, they see if your license and your card,
Yeah.
and it shows when it's good for. Now, if it says
So
good.
is it proof of future enrollment or proof of past completion?
The card?
Yeah,
The card just shows that you are a legally registered apprentice
yeah.
and have met all the qualifications.
Which
So
are that you have completed classes or that you are enrolled? Is it a past looking or future looking?
It's both, because you enter the program.
Yep.
And then you're gonna be going for 4 years, so.
Right.
You have to submit it each year showing that you're enrolled for the next year.
So it is a completion requirement and a future requirement, that I completed school and that I am continuing school annually.
Yeah, you've completed the first year of apprenticeship and going to the next, yeah, because just to make some clarification, you haven't completed the entire program. I just wanna make sure I'm not confusing with that,
Yeah.
the 600 hours. That you completed the first year of schooling, you're moving on to the second, and then to the third, and then to the fourth.
And this is unique to your profession.
I believe the mechanicals does it, but they have a 2-year.
Okay.
Yep, I don't know how many others have the 1-year renewal, but yeah, we've had this in place for quite some time.
Thank you for indulging my question.
Senator Perkins Cogan has a question too.
Yeah, thank you, Steve. And this is my fault because we had a call scheduled and I didn't get to talk to Simon, but there's a comment about including some language from HB 549 that we received, and I'm not sure where we would incorporate that, and I wondered if either you could speak to it or if it'd be better to talk about it offline, but it concerns reciprocity, which I'd love to incorporate, so.
Yes, I mean, I appreciate it, Senator. I do have a handout for you. I was just trying to get through the other stuff first, and I can,
Oh,
if you don't, I'll wait.
if you
and
were
just-
getting to it.
Yep,
Okay.
I just wanted, because I know it wasn't necessarily part of this bill, even though it does touch on it in these
Right.
sections.
Yes.
So, with regards to the allegations and complaint, just in general, we would appreciate a process that simply doesn't allow for an allegation or complaint if it's not valid, if the OPLC's found out, whatever, that stays on a record. It happened to me one time, and there was no justification for it. The homeowner was having issues with the contractor, he wasn't paying them, I was hired by the contractor. Long story short, he called the state on me, and I hadn't finished the job, I hadn't called in for an inspection, but he got the town to inspect it, so now they called me saying I didn't finish the job and there was violations. The well company did some electrical work, the boiler company did some electrical work, and it all got placed on me. So all we're saying is that give it that time to find out before it becomes part of our record. We have no problem with, but just, it was nothing to do with me, I did nothing wrong, but as a courtesy, the state inspector asked me to just go fix it so we could move on, and I did, but it just shows how easily that can happen, that's all. So we would hope that we can look forward to that. And though that being said, I was hoping to submit just some concerns with some reciprocity as far as keeping it clear, clarifying it if we could. And it was underneath So while he's handing that out, there was House Bill 594 had gone through, and it had to do with some reciprocity, and it put in some language, but didn't cover what's already existing in part of our rules, I believe, under RSA 332G14. Again, having to do with compacts, and it talked about it in this bill as well. Can find the page, but 332G is, as you'll see, is attached, has, in the very first paragraph is really all you need to look at. But it's pretty clear as to if you have a compact. So any board or commission regulating an occupation or profession, which is a member of an interstate license or compact, or which has in statute or by administrative rules a procedure for reciprocity or temporary licensure for individuals from other states, need not comply with this section for any license or certification by the board. So it goes on to determine the rest of it. And the first paragraph is basically saying, like, for us, we have an interstate compact, we reciprocate with 23 other states. We should have the requirements to become licensed or reciprocity online, but it's there, if it needs to be updated, we can do that. This 594 just kind of states that they can determine what's substantially equivalent, where our compact and everything else always have been. We would lose reciprocity with over 23 states if that could change without our board's input and stuff. So we were hoping to submit that as a possible addition to the amendment for this bill, if possible. And I'll take any questions.
Any questions from the committee? Senator Perkins Walker.
I don't know if you'll have an answer for this now, but I guess sort of the place it occurs to me to insert that is perhaps in the definition of license, have some kind of carve out. So maybe just think about a specific place for us.
For
For your request to specify that certain licenses are carved out under 332G14.
So if you look,
On page 2 with that, what you're
Yes,
thinking?
I'm sorry, on page 2.
Line 4.
Yeah, lines 4 and 5. I wonder if we should include some language there. I'm just trying
Okay.
to find the right place for what you're
right,
asking.
so in the first page I handed out, we kind of showed adding on to 310, what the amendment would kind of look like on 310AQ, add paragraph Roman numeral 3. It could be simply referenced for that section added into this, or we can add
I
it in.
see. Yeah, okay.
It could be at the end, just as a separate line item, is under 310QA, insert this wording so that it's, if you meet that, then you're covered.
Okay, I'll think on it. Thank you, Steve.
Thank you.
Further questions? Seeing none, we thank you, Steve. Appreciate your input. Is Tara back? I saw her walk. We'll go to Kimberly Kirkland.
Great.
I know Tara was here. She must have stepped out.
Good morning. Thank you for hearing my testimony. I'm Kimberly Kirkland. I'm an attorney in Manchester. I'm also the president-elect of the New Hampshire Association for Justice. But most relevant, I think, to these proceedings is that I taught civil procedure and professional responsibility at UNH Law for 15 years. And this is a bill about procedure and professional responsibility. So it's right in the bailiwick of what I taught for many, many years. And I just have a couple of concerns in this amendment. I think it's a terrific effort to create a single streamlined procedure for the OPLC. I think that enhances transparency for both the public and for members of professions, and that's hugely important. So I think this is well worth your effort, and I know it's been an enormous effort. I've attended a number of these hearings over a fairly lengthy period of time, so I think you're almost at the finish line, and I just encourage, in pushing it through, for you to look at making sure that the amendment maintains the distinction between the investigatory function and the adjudicatory function. So I think the initial bill did that, and I'm not sure why There was a change made on page 9 under Roman numeral 3 on line 13, which is dealing with the time and the process for each claim of misconduct that's come into the OPLC or the board. The OPLC has now made a determination that if everything the complaining person says is true, that there actually could be misconduct here. And so it's something that needs to be investigated. They've made that determination. And now we're adding, upon direction of the board, the office shall investigate allegations of misconduct. The board is going to be the adjudicatory body. The board is going to decide, once an investigation has been completed and evidence is presented to it, hearing what happened from witnesses, understanding the professional standards coming from experts. Yes, this was misconduct, or no, this wasn't misconduct. It's important that when they go into that function, when they take on that role, they didn't have any hand in the investigation, so that both the complaining member of the public and the professional know that this is entirely unbiased, jury-like function that the board is providing. And if the board is allowed in any way to direct that investigation, the consumer could view it as the board sort of underplaying the claims, and the professional might think that the board for some reason has it out for them. And so this, I think, is to the benefit of the board too, because it keeps their hands clean. But I think it's very important in terms of the fairness of the process, both in actuality and in perception, that those two things be separated. And so I would just suggest that it would improve the legislation if the upon direction of the board language was deleted. Okay. And then related to that, on line 25 on the same page with respect to experts, it says retain qualified experts approved by the appropriate board. In some of the prior hearings, I remember there being some comments that people, members of professions, were concerned that if there was a subspecialty involved, that a person with training in that subspecialty be involved in the investigation to determine whether there really was enough to go forward with some sort of disciplinary proceeding. And so I think that might be where this came from. I think maybe the board could indicate, once the OPLC has determined that there is merit to the claim on its face, okay, investigate, and it looks to us like this is the subspecialty that is involved, but I would encourage you to make sure that the language makes it clear that the board is not picking the expert, because that again puts them in the role of investigator, and it could be viewed as they're trying to skew the result one way or another by picking the expert, particularly in a small state where they know each other. Often, you know, you might pick your friend or your spouse or somebody to do the investigation. So I think the OPLC is well qualified and has the resources it needs to identify and choose somebody who is credentialed and credible and will give an objective, reliable review. But I wouldn't have the board actually taking part in choosing who that expert is. And then finally, I would say, with respect to the allegation versus complaint language, I heard the testimony from the members of the Mental Health Board and the Board of Psychology. I understand that there is a concern about when in the process the public or an insurer might think there's legitimacy to a claim and that that might be damaging to the professional. But I would say, with respect to due process, the way we think of due process in the legal system under the Constitution is that there are places along the way where you are given an opportunity to voice your side of the story, and that the judgment is made by somebody neutral. And the fact that a complaint is made, an allegation is made, is not a determination. And I don't think that we should assume that the public or insurers across the board, for all of the boards involved here, would make an assumption that just because somebody says, oh, this professional engaged in misconduct, that that's true. I think it's pretty well understood in our system that we have a rule of law, we have due process, and that just because somebody's made a claim does not mean that it's been substantiated. There's a process that's going to be followed. So I would just, I don't think due process requires this distinction between the terminology of allegation versus complaint. And as I read it, it's a little hard to define the distinction here. So I do think that could, that distinction is artificial as it's put forward in this amendment. So I'd be happy to answer any questions.
Oh, well, thank you. I appreciate your testimony. Any questions from the committee?
All right, thank you
Seeing
very
none?
much.
Hera, you're back. We'll put you on now. Yep, come on up. Turn your mic up. There you go. Thanks.
Thank you and good morning. My name is Tara Reardon. I am an employee of the New Hampshire Community Loan Fund, and I advocate on behalf of the 146 resident-owned communities, manufactured housing communities here in New Hampshire, a really important and critical source of affordable housing for us. I was glad to see the amendment to amendment number 1499 to House Bill 532 because the Manufactured Housing Board still exists at this point, and I think this path to preserving that board is really critical. We're working in a parallel effort to remove that repeal from HB 2. But under these circumstances right now, that Manufactured Housing Board would still exist with the archaic board makeup and provisions that this committee heard back on February 15th in Senate Bill 203. It was a great hearing here. This committee was all on the same page. Senator Carson, Senator Perkins-Coker both came up with amendments that were really good and improved that board. And in fact, on the Senate floor, it was unanimously adopted and sent over to the House. The House eDNA did replace that bill with just preserving the website for the Manufactured Housing Board for 5 years because of the great information and the service that it is to citizens that exists. But I had a conversation with Representative McGuire at the time, and she said the House had already passed out HB 2 at that time, and they were trying to be consistent with that position of the House. So I would love the good work that this committee already did on Senate Bill 203 to survive and not just the archaic provision. And I will also add that House Commerce last week had a subcommittee on another manufactured housing bill. And in fact, they're going to spend the summer to recreate the Manufactured Housing Board all over again while it still exists at this point under RSA 205A. So I have great respect for the positions that the House has taken and the Senate has taken to this point, but also want to be more efficient about the process if we possibly could. So to take those Senate Bill 203 provisions, including the improvements made by Senator Perkins-Coker and Senator Carson, and put it in this bill would make that where we were back on February 15th with a lot of great testimony from residents whole again.
All right, thank you. Questions from the committee? We will give it some consideration. Thank you. So I have Shannon Lane signed in support, Wendy Chase signed in support, John DeJoy, I believe, signed in support. Anybody else that would like to speak? Come on up.
Thank you, Mr. Chair, members of the committee. For the record, my name is John DeJoy, representing the New Hampshire Psychological Association.
Oh, I'm sorry, John, you didn't check off the speaking box, so I didn't know you wanted to, but go ahead, you're on.
No, I was running between hearings. I didn't want to leave you in the
Okay.
lurch. New Hampshire Psychological Association, also known as NHPA, is the state's membership organization for psychologists. NHPA supports the amendment put forward by Senator Perkins Coker. I'll just make a couple of references. In 310.2 on page 1, the definitions, we understand, and we have met with the director regarding the definitions. We understand the conflict between allegation and complaint. That's fine. We do believe, though, there needs to be an additional definition. We would refer to it as founded complaints. I believe the director referred to it as docketed complaints. To define what that means, it's an in-between step moving on towards investigation, and that would help psychologists in terms of their reporting around their malpractice insurance. In 310.9, we support that section. Generally, this is on beginning on page 8. Just a couple of comments on that. On page 9, and you've heard this reference, line 13, adding upon direction by the board, I think that inadvertently raises significant confusion, because in page 9, line 13, by adding upon direction to of the board, and then beyond that saying the OPLC can begin investigations of their own accord, it raises conflict what the true intent is of that. So in terms of the same page, line 25, retaining qualified experts, heard Ms. Kirkland's concerns, agree with her that the board ought not to be in the position of selecting the investigators. However, we have asked repeatedly to direct OPLC to promulgate rules of what the criteria are for these subject matter experts. We think that's rules are a better place for that. It gives the boards the ability to weigh in on the rules without actually selecting the investigators. And finally, in 310.12, let me find a page number for you. (310.12) is on page 16. The actual reference is on page 17, line 12. This is in regards to when when a licensee is found to have committed misconduct, they can be charged for the cost of the investigation. Current law listed at $10,000, $655. Remove that. We appreciate you adding back in the cap on that potential liability. And with that, just that NHPA supports the balance of this amendment.
Thank you. Questions from the committee? Seeing none, thanks for coming in. Anybody else would like to speak on this? Seeing none, I'll close the hearing on amendment 1499. start.
Go ahead and open the public hearing on amendment number 1660 and recognize the prime sponsor, Senator Pearl.
Thank you. Good morning. For the record, my name is Senator Howard Pearl from District 17. I'm going to just quickly go through the changes that this bill, this amendment makes, and I know Senator Rosenwald is here to explain a portion of it that is hers as well. So this amendment is a replace all. The first section, which is section 7, I know that I had to read that a couple times too, is the original bill that was dealing with the licensure and certification of music therapists. The next section, which is section 8, was OPLC asked that we add this provision, and this revises certain licensing criteria for the barbering, cosmetology and aesthetics licensure. Section 9, again, was asked, OPLC requested that we put this in, and provides a licensing exemption for some physicians licensed out of state to treat existing patients in New Hampshire. Nope, that's the wrong one, I'm sorry. That's the booth rental, my apologies. That is removing the booth licensure component, and I'm going to let them explain their reasons on that. I think they'll do a better job than I will. Section 10 was requested by Senator Rosenwald, and that deals with the licensing exemption for physicians out of state, so I'm going to let her explain that as well. Section 11 is the optometry, and this was a technical change that removed the word annually because of, I basically just removes the word annually from their requirements, and this was requested by the optometrists to have that change. Section 12, as you can see, this is a whole section of different changes. The whole bill is made of that. This included the physician assistants in telemedicine, as they were inadvertently left out. It adds them in the RSA 328D edition on line 17. Section 13 was adding the naturopathic doctors back in, as they were left out of the telehealth services. So that's on line 27. We're adding naturopathic doctors governed by RSA 328E. Let's see, section 14 was a technical change by the requested by the Division of Administrative Services, and this again was another administrative. I'm trying to remember what this one did. Well, this was one that they had asked to be removed as it was no longer needed, and I'm trying to remember if that was because of 655, but I'm sorry, I don't recall that detail. But this was a request that they made to have that section removed. So that's a quick highlight of the overview of all that the amendment does. I certainly will try and answer questions, but I think we'll probably get them all answered as we go. But if anybody has any, I will.
Thank you very much for your testimony, Senator. Are there any questions from the committee?
All right.
Seeing none, thank you. Okay, the chair will call Senator Rosenwald.
Thank you, Madam Chair. For the record, Cindy Rosenwald. I represent Senate District 13, and I'm here to speak to Section 10, which begins at the bottom of page 1 on line 31 and just goes to page 2, line 4. This is an attempt to address a problem that I think a number of our constituents are having who seek occasionally medical care in other states. and where they have an established relationship with a physician, and this is only about physicians located in another state. However, if they then want to have follow-up telehealth appointments with that physician, they have to be physically located in that state. So the example that a constituent brought to me recently was his wife's doctors to treat her Alzheimer's are all located in Boston. She has a well-established relationship with them. They see her as needed. But he does a lot of her telehealth appointments because she's not capable. He has to be physically located in Massachusetts to do that because these doctors are not licensed in New Hampshire. So sometimes he goes to the public library in Chelmsford, where there's a little room he can use, but the Wi-Fi is bad. Sometimes he sits in a parking lot and tries to do a Zoom on his phone with these physicians. And so this small exemption would just allow a physician to not have to be licensed in New Hampshire when there's an established relationship with the patient in their home state of licensing. So if it's part of a compact, forget it. It doesn't count. And they see the patient at least annually. And I think for those of us who live in any of the border communities where patients might be seen in Maine or Massachusetts or Vermont, it would be very helpful for our constituents. And I think it's a very small carve out. OPLC is fine with it. The New Hampshire Medical Society didn't have any problems. I spoke to the chair of the Board of Medicine. They didn't, she said, if you want a real vote, I'll have to put it on the agenda for a meeting, but I don't personally see any issues. So I hope the committee will adopt this section. Thank you.
Thank you very much for your testimony, Senator. Are there any questions for Senator Rosenwald? Senator, I want to thank you for bringing in that section. You and I both live in communities that are very, very close to the Massachusetts border, and we have a lot of folks that have moved up from Massachusetts into southern New Hampshire, and this is one complaint that I have gotten consistently, that they want to keep their established doctors in Massachusetts, but they can't receive treatment. They have to go and cross the border to access that treatment, and I believe this section will fix that problem and will improve healthcare in the state of New Hampshire.
Thank you. Can I ask one question?
Sure.
Because I missed the first bill. You and I have been dealing with a nurse issue from Southern New Hampshire Services. Has that been addressed somewhere?
Thank you. In fact, they're drafting the amendment, and I'm waiting for it.
Yay,
so
thank you.
It's drafted, so they're just, in fact, I had just called Matthew before I came back in to really find out where it is, because I told him I wanted it by 9 o'clock, and I haven't seen it yet, so, okay, thank you.
Representative Perez, did you want to speak? Yes. Okay, come on up.
Thank you very much for allowing me to speak. My name is Maria Perez. I'm a state representative from District 43 in Milford. I'm here to speak on support of the amendment. As someone who lives in a rural community in very small town in Milford, it's really hard to see some of my constituents asking in the Milford Facebook page, how and where can I go close to the Massachusetts border that I can receive the help that I need? It's very sad to see patients that they really need the help, but they have to drive to like Senator Rosenfeld just said, libraries, coffee shops in Massachusetts just to receive the treatment that they need. So that's why I'm very grateful and I'm here to support the amendment because it's really needed right now for a lot of our constituents at the state of New Hampshire. Thank you so much for your time.
Thank you. Any questions? Seeing none, thank you. Good to see you again. Okay, Jessica, come on up.
Good morning. Jessica Kalapolitis, I'm the Enforcement Division Director at OPLC.
Douglas Osterhout, General Counsel for OPLC.
So the portion of this amendment that I would like to speak to has to do with the booths. So the agency, OPLC, does support this provision. The Barbering, Cosmetology, and Aesthetics Board does also support this provision. I'm happy to answer any questions if there are any regarding what booth licensure is, but briefly, within a shop, the shop is licensed. All the individuals providing services are licensed. And then certain other individuals have a booth license, and that's based on the arrangement they have with the shop owner. If they're an employee, they don't have one. If they rent a booth, they must get an additional license, which that's this booth license. It does not protect the public to have somebody in such a situation have yet an additional license. They do have their individual license, and the shop itself is licensed. So it's based solely on the arrangement that they have with the shop owner. So what this would allow is for those people to not have to seek an additional license based solely on that relationship.
Anything further you want to add? You good? That seems simple. Any questions from the board? Seeing none?
I just want to address on page 2, section 14, the repeal of former APLC administrative provisions. I just wanted to point out that when we amended 655 in the House, when it was still around 78 pages long, I went ahead and added this in, but I did it right before the effective date, and when they pulled the back into that language, this was inadvertently removed as well, and I've been panicking ever since, and I want to thank the committee for putting it back in there.
You're welcome. Further questions? All right, seeing none, thank you.
Thank you.
Curtis. You can explain to us why annually needs to be removed.
Yes, sir. Good morning, Mr. Chair, members of the committee. I'm Curtis Barry here this morning on behalf of the New Hampshire Optometric Association, representing 170 doctors of optometry here in the state. The New Hampshire Optometric Association does support this change, but the change comes to you as a request of the Board of Optometry. You should each have a copy of the letter that was sent a while ago. They voted to support this change. And essentially, it's really quite simple. When the license renewal for optometrists moved to every other year, this provision in the statute was overlooked. It still requires them to report continuing education on an annual basis, and that caused some confusion this year, because this was not their renewal year. So the Board of Optometry again voted to ask for this change, so it deletes the terms annually in the statute and allows them to move to every other year reporting coincident with their license renewal. Simple as that.
Thank you. See, I knew you'd do a better job explaining it than I would. Questions? Seeing none? Oh, this is...
Oh, I'm sorry. Yeah, it's page 2, line 11, my fault. Page 2, line 11 of the amendment.
Yes, that's what we're doing with the amendment.
Oh, okay.
Yeah.
I thought you were looking for, this was an
No.
action item.
No.
He's explaining what I was doing.
Supporting
Yes.
section 11, yeah.
Further questions? Seeing none?
Thank you.
I have Shannon Lane signed in favor. Anybody else that would like to speak? Yeah? Senator Carson?
Thank you, Mr. Chair. I'm going to ask the chair for a little leeway. The amendment that I have is in the final approval process.
Okay.
And so can we put the committee into recess for perhaps 15 minutes while that gets finished up?
We can recess this hearing, and then we could go into exec session and work on some other bills if we wanted to.
Okay.
If the
Okay.
committee- So with that, I will recess the hearing.
Oh, he's running it down right now? Okay, because I just went and they said it was being reviewed, so, okay, so.
So he's
It's
on
coming.
en route? All right, well, I'll tell you what, we're gonna take a 5-minute break, and then we'll come back. All right, we're gonna come back out of recess, and I'm going to recognize Senator Carson because she wants to introduce an amendment to the amendment to the amendment? I don't know.
Okay, good morning, Mr. Chairman, and good morning, fellow members of the Senate ED&A Committee. For the record, my name is Sharon Carson. I have the pleasure of representing Senate District 14, comprising the towns of Londonderry, Hudson, and Auburn. And I have for your consideration this morning Amendment 1743S to House Bill 532. Mr. Chairman, I had received a request from the Southern New Hampshire Services Organization. They deal with nursing issues, and they deal with the nursing board. They have convened a group called the Southern New Hampshire Nurse Leaders and Nurse Educators to work collaboratively together to help with workforce concerns in the nursing field. According to an email that I received, they have had great attendance, and so they have requested 2 legislative items. The first is an addition one more addition to the board, which would bring it up to 12 members, that would deal with nursing education. They feel that we need a very strong voice on how our nurses are educated in the state of New Hampshire. It would require that this new board member have a minimum of a master's degree in nursing or health-related field and have at least 5 years of educational experience in a nursing program offering a degree leading to a registered nurse license. The second request that they had deals with allowing the Board of Nursing to have the authority to have committees. It's my understanding from the information that they provided me is that they already have the authority to do this in nursing 102.5 rules, but they would also like to have that reflected in statute. So if you look at the amendment, the addition to the board begins on line 9 through 24, and the new paragraph to establish subcommittees begins on line 25 through 28. And I will try to answer any questions, and thank you very much for the opportunity this morning, Mr. Chair.
Any questions from the committee? Yes. Senator Altshuler.
Thank you, Mr. Chair. I think I'm not reading this properly.
Okay.
9.6, amend the bill replacing all after section 7 with the following, and then, so.
Yeah, we'll have a conflict there with the other amendment, but we'll fix that.
Yeah, there's because
Okay.
we have so many
The intention is
amendments
not
here.
to get all,
No,
okay. I was
No.
like, wait a minute, what did we just do for the last 2 hours?
I know.
Okay,
It's-
I got it. All right, so
Okay.
that is not the intention.
no,
Thank
not
you.
at all. It was
All right.
just in the drafting, and this was done very quickly, so.
Thank you for the clarification. Now I get, we're gonna fold it all in together.
No
Thank
worries.
you.
So I guess the only question I would have is it wise to make an even numbered members to the board? Because the question you always arises, how do you have a vote and not have a tie?
Senator, I agree with you completely. This was a request that they add an additional member. I think we can, as a committee, work on that. We can take a look at what are the duties and responsibilities of each board member, and perhaps one of those positions can be amended. But they definitely do want to have someone who deals with nursing education. I think that that's very, very important, and I'm surprised that the board does not do that now. We have a lot of different programs for nursing, beginning with our community college system, right through to master's programs. So I think it's good that they would have a voice on education programs.
Okay, well, we can work on that. Thank
We'll
you.
work on
That was
that.
just the one thing that jumped out.
Yep.
One more question.
Senator Altshuler.
Yeah, thank you, Mr. Chair. Thank you for answering my question. In your discussions with them, did they have any thoughts about what their quorum would be so that they can actually continue to do their business? Because
I don't, thank you, Senator. I don't believe that it would necessitate a change at this point. I think if we were adding 4 or 5 people, we definitely have to look at the quorum requirements. But again, I think this is an area that is going to need some work because I understand the chair's concern about having an even number.
Right.
So I mean, I think that if the committee feels it's appropriate, we can look at a quorum change as well.
Yeah, and thank you. Follow up. In addition to the 3 things, yes, the odd number, like 11 or 13 maybe, the quorum, and are they allowing, are they interested in having the ability to do hybrid meetings if they have statewide membership to be able to achieve their quorums?
Senator, that was an issue that was not discussed.
Okay.
But I do believe in judiciary, we had a bill dealing with online meetings, dealing with state boards, and would allow them to do that. So since this is a state board,
All right.
so.
It's just come up so many times that.
Right, and I agree.
Particularly around getting a quorum.
Yep.
All right, thank you.
You're welcome.
Further questions? Senator General.
Thank you, Senator Carson, for taking my question. The only thing I would have out of a curiosity standpoint, it says all terms shall be for 3 years. Are those consecutive years, so they'd be appointed, so all of them would come off the board at the same time, or will they be staggered?
I believe, Senator, that they're already staggered.
Okay.
In terms, because you don't want to wipe out a board completely. I think we all know the difficulty that we've had in getting folks on these boards, and I believe that they're staggered already.
Okay.
So.
Thank you.
Further questions? Seeing none. Thank you.
Thank you very much, Mr. Chair.
Director, is there anything that you'd like to comment on this? I know you were.
Thank you, Mr. Chair. Lindsay Corning, Executive Director, OPLC. And I know that we've just seen the bill and that there are some things that I think we all need to discuss. Just reading it now, it appears to me that clearly the even number of members could be a potential problem. We typically like to have odd numbers just for quorum purposes. Additionally, I want to note that the Board of Nursing has been engaged in this dialogue with stakeholders regarding this education piece. And there's another side to this that I think it may take a little bit more time to flesh out. That being, education programs are regulated and approved by the board. And so when you invite somebody who is a part of a program that is regulated by the board to participate in the decision-making regarding competitors, that can be a problem. And we've seen that happen in the past where people are privy to documents regarding competitors that they would not otherwise be privy to. And so I think it's a little bit more of a complicated issue than just receiving the input. And at this point, the Board of Nursing has not decided to move forward with establishing a committee. Part of that is because we've advised them based on the advice of the LBA and the dental audit that they don't have statutory authority for that. But I would say that maybe we should take some time to consider this issue before making a modification. The other thing, lastly, that I would comment on is that the move to 12, an increase in members, is just not consistent with what we saw out of the governor's proposal in HB2, where there's been this request to reduce the number of board members. The Board of Nursing is very well functioning. There's no concern with respect to their ability to conduct business at this time, and I would say that maybe we need to take a little bit more time and get their feedback as well. Thank you for the opportunity to speak.
Thank you. Questions? Seeing none? I know this is a new, little bit of new language. Is there anybody else that would like to have any input on the amendment? All right, seeing none. Thank you. So we're gonna close the hearing officially on Amendment 1660, and I would take a motion to go into executive session.
So moved.
Do we have a second? Second. All in favor?
Aye.
Okay, so as I stated before, I don't want to exec either of these, obviously. Give that to Tucker so I don't get it mixed in my papers, thank you. I don't want to, we know we have some work to do on this 532 amendments, so I would say we will not want to work on that. Sorry, I'm quickly fumbling through here. We have a deadline for fiscal note bills, and I've asked Senator Bradley to hold the calendar for us for next week, so that we can exec next week and still meet our fiscal note deadline. So we are able to do that. So that's why we're able to hold 532, and we'll hold 409 too, because the two of them are kind of working in conjunction. But we do have a couple others we could potentially work on if we're ready to. Senator Carson has brought in an amendment here someplace to 421. So I guess we could start with that one if you're ready to.
Thank you, do you want a motion?
Would you like a motion?
Yes, I move to pass on House Bill 421.
Do we have a second?
Second.
Moved and seconded. Senator, you have an amendment you'd like to offer?
Yes, thank you very much, Mr. Chair. I have Amendment 1589S that I would like to introduce. This language should be familiar to all of us. We had a Senate bill earlier this year that was Senator Whitley's bill, and we passed it unanimously. It went over to the House. The House has decided that they were going to not pass that bill, and they sent us House Bill 241. So we had a meeting with the stakeholders, Senator Whitley, myself, Devin Quinn, Jane Graham from the Commissioner's Prisons Office, as well as, and there were a few other people, Marissa Chase from the trial lawyers, and the superintendent of the county jail from Stratford County. And we talked about the bill that we received. The bill they felt had gone too far, and that the addition that we saw in House Bill 421 in many respects was not workable at this point in time, and they felt that it was such a big addition that it should have a separate bill in the fall, especially concerning the extent of providing clean underwear, clean sheets, and uniforms upon request. I discovered that they launder clothes differently. The state prison, everybody puts everything in a nice little bag, and that way it gets back to you. But in the county jail system, everything is washed together. So if you received 5 pairs of new underwear upon admission to the county jail, there was no guarantee you were going to get those back. And the population at the county jail is constantly moving, where someone will come in for a couple of days, but then they go out on bail, and then they come back. So there was a lot of questions about providing these products for people that were in the county system that we just couldn't seem to find how this is going to work. So what I did was I took Senator Whitley's bill, and this was with the consent of Senator Whitley, as well as the other members of that group that was together, and wiped out all the language from House Bill 421 and created an amendment with the language from Senator Whitley's bill. So that's all we did.
So you're moving this amendment?
Yes, I am, Mr. Chair.
Do we have a second?
Second, and just one question. if I
Further
may.
discussion?
If, so the language that's in front of us in 421 is as amended by the Senate?
Yes.
Yes, okay,
Yep.
great.
So this is the bill we've already passed.
Yes, this
Okay.
is the bill we've already passed.
Further discussion? Seeing none, all in favor of the amendment 1589S, say aye.
Aye.
Any opposed? Seeing no opposition, the amendment passes. Excuse me. And we'll, so now the vote is on ought to pass as amended, is moved by Senator Carson, and I don't recall Senator Gendro seconded. Any further discussion? Seeing none, all in favor? Aye.
Aye.
Any opposed? Amendment passes. Who would like to
I'll
move
do this.
move consent?
Yes, I'll move consent.
Second.
All in favor? Aye.
Aye.
And Senator Carson will take this one up.
Yep.
Is there any concerns on, I'm looking through the list since we're right here, House Bill 454 is the next one in my binder.
I'm sorry, what are you looking at?
House Bill 454.
454.
We had a question on that, Mr. Chair, as far as it really taking care of what we were hoping for.
Right.
So I know we had discussed maybe a re-refer or looking into it a little bit more.
We've had another couple of weeks. What's the pleasure of the committee on this one? I know, I agree, our concern was, is it really accomplishing what the intent was? Thoughts from the committee members?
Oh, no, Senator Rose,
Also,
Altshuler had
yes.
her hand up.
I'm sorry, I didn't
So,
see you.
no worries. So on the first, I don't know, is this page 2? No, page 1. On lines 9, at least 2 of the public members of the board shall be a person who is not and never was a member of the medical profession or the spouse of such a person, or who doesn't have, never had a material financial interest in medical services. Like, I don't think we could have gone further away from trying to find somebody that literally knows nothing about the industry. To what end? Like, why? Why? I wouldn't want me on the board of medicine. It's not my field. And I wouldn't be recruiting to me to be on the board of medicine, because not our field, like not our lane. Don't have any expertise. I just feel like that's a,
Could it be that they are looking for people that don't have a dog in the fight?
well,
And
they
it's-
also don't have any, they also don't have any, like, background in the fight. You don't have, I mean, there's a reason that, we go to doctors and not ask, our neighbor, or some people do go to Dr. Google, but that's not, that's not how we make policy, medical decisions, about the board, not, it's an art and a science that is practiced over a long period of time. And the specialties are vast and wide. So, having people from all factions of this world, excellent. But, my landscaper is a great, great guy who runs an incredibly large and thriving business, but has absolutely no business being on the board of medicine, and nor should his doctor, be talking about landscape architecture. Like,
So this certainly is, I think the genesis of this was the issues that occurred with, the bad actions of some, if I'm remembering correctly. And while is there any interest in the committee? I mean, I understand what the bill is trying to do,
Yes.
but I just don't know if it gets there.
this doesn't do it.
So is there any interest in the committee on re-referring and working on this and trying to find a path forward? Because we certainly, I don't know what it is myself yet.
Chair, I would support that. I think we all care deeply that our patients get this care, and I think we want to make sure that when we address this, we do it the right way. So I think re-refer would make sense in this case.
I make a motion that we re-refer.
For a second?
You want a second? Or you want to?
I want to ITL it, but.
Oh, okay. Second.
Okay. So we have a motion to re-refer and a second. Discussion. Go ahead. You have a different opinion than you?
Yeah, I'm, re-referring it throws it back on us
Yes.
to fix what was like not really well crafted and didn't address the problem at hand. And, if we were to ITL it, come back and do it again, like do it differently. This, there's some not bad ideas here, line 14, public transparency advocate, which, really you're looking for an ombudsman. Not, the public transparency advocate is really, we can have more transparency with an ombudsman, which gives another opportunity for people to interact with a board prior to things escalating. Like sometimes we can work things out at the ombudsman level.
Senator Krause.
Thank you. I think that having the two members of the board do this, I think creates a conflict. If you think about it, they're going to be, what if they disagree with the board? What happens then? Who has the authority to override their decisions? I mean, to be honest with you, Senator, I kind of like the idea of having an ombudsman, somebody who is outside of the board to deal with transparency issues. And I think we know, and I believe we heard in testimony, that a lot of the complaints, they take a long time to wind through a board. So oftentimes, if someone's license has a complaint made against it, that process can take a while.
Yes.
In the meantime, they're still seeing patients. And so I understand the need for clarity and transparency. I just don't think this bill gets to it, and I agree with your motion of ITL. The sponsor of the bill said that he chaired a committee that dealt with this issue. So he's already done a deep dive into a lot of this. I think if we were to ITL it and say, look, we're not comfortable with this form, come back with something in the fall, I think would be appropriate.
I'll withdraw my motion to re-refer. I think you're exactly right.
You withdraw your second?
I will, Chair.
All right, motions have been withdrawn. Is there another motion?
I move ITL.
Second.
Moved by Senator Carson, seconded by Senator Altshuler. Further discussion? Hearing none? All in favor of ITL?
Aye.
Any opposed? Move consent.
I'll make the motion, Mr. Chair.
Do you have a second?
Second.
All in favor of consent? Aye.
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 Senator Altshuler, would you like to take this one out?
Sure.
So we're going to hold 409, we're holding 532, we're going backwards through the pages now, sorry.
Are these gonna show up tomorrow or not till?
No.
No, okay,
No,
they'll not
then
be
no,
on.
they'll be next week.
okay.
Yes.
Just wondering, I'm just, because I
No,
usually
they'll be
like
on.
to make Philip sweat by not approving my, and getting a multitude of texts from my aide, like, can you just say yes on the thing?
I definitely wasn't approving words last week while visiting baby animals at Strawberry Bank.
So the next one back is 358. I'm just pulling up to see what my notes are on that.
Pre-apology, Philip. It's a pre-apology, you know what's coming.
Okay, 358 is one I have been working on. This does not have a fiscal note. I want to hold on this one a little bit longer. Sorry. I've been working with, I've been in contact with, just update the committee, I've been in contact with HHS about their process because Carolyn Virtue came in and raised concerns about rulemaking being promulgated by waivers and not by statutory or 541A authority. So I've been looking into that and digging into it. I've had a discussion with HHS, and I need to go have a discussion with the OLS rules attorney, Mike Morrow. I just haven't had the opportunity to get there. So I'd like to hold, and again, we don't have a fiscal note on this one, so we've got a little time we can sit on it. I'd just like to make sure we're doing a good job on it. 37.
This is 250.
Yeah, I'm going backwards, kind of.
It's okay.
337.
Is that one?
I remember what this was.
OPLC raised some comments in the hearing. I think you guys had a meeting with them.
Yes, we have an amendment actually to that, don't we? Yes, I drafted one. I just have to figure out where it is.
There's this handout that I got from May 2nd.
Yep.
Okay.
337.
Oh, yeah.
I have an actual amendment to this.
There's an amendment to this.
Tucker, could you run down to Peter and have him print off that amendment? And I'll skip over this and go to a different one for right this minute, because there is an actual amendment drafted to this. My apologies, committee, I didn't bring that with me. I got a little consumed by the others.
All right, so.
House Bill
skip it for a sec.
250, let's go back to that one then, while we're finding the amendment.
Mr. Chair, on 250, I'm really kind of torn on this one, whether or not we should ITL it or whether or not we should retain it. It was interesting, we got conflicting testimony. I still see why this needs to change. It's not justified. There's no definition of accidental death here, and it's workers' comp that determines the accidental death. I'm sorry, I'm talking without even making a motion.
You're fine, we can have a little discussion first.
Yeah, I'm not sure if we should just retain this and work on this, so there can be some more clarification on this. But I just thought it was interesting that we had we had conflicting testimony. We had testimony from finance, House Finance, that thought this was a great idea, but then from House ED&A, they struggled with this.
Yes.
So at this point, I don't feel comfortable passing it. I do see it has some merit. I think we just need to work on the language.
I have concerns with the way this was set up. It was following the increase in pay as you go through, and throughout the years, and it's a bill that's worked for, I don't know, when was it last done? It's a bill that's been in effect for quite a number of years, since '04, it looks like, without any issues. But if we change this and put a cap on it, the way that it's doing, we're potentially gonna bring this back to us again in maybe not too many years either, so.
Yeah.
The last time we actually changed that was in 2014. And I'm just checking to see if accidental death is defined.
I certainly understand what they're trying to do, and I am not having any issue with some parts of it, but doing it that way, I think, just creates a problem, or creates a situation where we're going to be looking at this again in not too many years.
Yeah.
Senator Carson.
Thank you, Mr. Chair. I believe this only applies to Group 2 members, and I have an issue with that. I think we know that our state employees sometimes are killed.
No, it's Group 1 and Group 2.
Oh, is it?
Yep.
Because, I'm looking at the amendment from Senator Susie that she presented to us that was just dealing with Group 2. So if we were to adopt this amendment, Group 1 would have one standard, Group 2 would have a different, and I don't know if that's fair.
No, it's not,
I can speak to that if it's helpful.
It's for a
Yeah.
retirement system member, for retired.
Right, and I'm looking at her amendment, and it's accidental death benefits, Group 2.
right,
So
which was
it's
in the
sep-
original.
Right, so why would Group 2 receive the benefit with the maximum amount of not exceeding 125, and why would we cap state employees and teachers at 85?
It's because Group 2 is not eligible for Social Security.
Okay, yep, that's
So
right.
There's actually a difference in how they're treated.
Right, but, and the accidental death is an accidental death.
And I think that originally that policy was started because the life expectancy is lower, and so they weren't going to get all the way to being eligible for Social
Yeah.
Security.
I just think this
Yeah.
perhaps needs more work, that's all.
Would you like to make a re-refer motion?
Yes, Mr. Chair, I'd like to re-refer House Bill 250.
Is there a second? I'll second it, because I think we should work on it too. Further discussion?
Yeah, I don't know what more there is to work on, other than we discussed in the, at length, actually. And in my notes, the last thing we came up with after going over the Group 1, Group 2, and why the differentiation was there, as highlighted by Senator Perkins Quokka, was in the original amended by the House on line 4. We had a question of why not keep it at the rate of earnable compensation and not cap it at 85,000.
Well, Senator, I think, may I
Yeah.
respond? I think that's a good reason why. Why we should take a deeper dive into this. Also, we're not talking about the money coming from pensions, we're talking about the money coming from the state.
Yes.
So, at that point, I mean, I just firmly believe that our state employees, even though they are getting Social Security, should get the same amount from the state.
Yeah, not the Group 2, though.
So I think these are all, I know the notes that I had concerns with the average final compensation formula, using that standard. I had concerns with the $85,000 cap, and I'm not 100% convinced that we should use 100% as a number either. I thought maybe a little different number and remove the cap, so that we were still protecting the general fund dollars, but not doing it with a cap, so that we didn't run into that rising wage issue in the future. So, those were thoughts I had, that I had jotted down. Yes.
Mr. Chair, I mean, we're talking about individuals that have died accidentally in the line of duty, whether it's a state worker who was working on a highway and got hit by a car, a teacher that has been beaten to death, because we're seeing more and more teachers being assaulted in our schools. You're talking about, of course, police and fire that get injured on the job and they died. Are we going to determine whose life is more valuable depending on whether or not they receive Social Security? I don't think that that's appropriate at this point. I think a life is a life, and a loss is a loss to every family. And we're not talking about money coming out of our pension system. We're talking about money coming out of state funds. And I think Group 1 should be treated the same as Group 2, because their life, and anybody that's in Group 1, their life is just as valuable as somebody else's life in Group 2.
So, Senator Carson, would you be open to passing the bill without Senator Sussie's amendment, or acting on the bill this year without that amendment?
Thank you for the question. I think that Senator Pearl, our chair, has raised a number of important points. I know that there were points that I would like to deep dive in, because what's an accidental death? What qualifies as an accidental death? I mean, are we going to take the version that comes from the Workers' Compensation Board? I just think if we're going to raise this benefit, we need to make it universal for Group 1 and Group 2, and define what constitutes an accidental death. I think all of that information needs to be teased out in an amendment, and unfortunately, we don't have the time to do that right now. So that's why I would like to re-refer the bill.
Okay.
I will say this, we have one more week that you can, if someone wants, if we can hold off on this for, till next week. If some of you want to take a stab at this and bring an amendment in, I personally don't have the bandwidth to do it. I've got so much going on with the other amendments, but if one of you wants to take this on and come back with an amendment, we can hold on executing this till next week.
I'll give it a go.
Okay.
Yeah, because I'd love to
Would you
see
be
us do
amenable to that?
something.
And then if we can't, we can
Yeah.
re-refer it next week.
Okay.
If we choose to.
Thank you.
Would you withdraw your motion?
Yes, I withdraw my
You'll
motion.
withdraw your second? All right, then we'll hold off on 250 until next week. And Senator Altshul, I think you have a good sense of what the committee's concerns are. I look
Yes.
forward to seeing what you come up
Let's
with.
try to,
Could I, just another
over that
question
hump.
too?
Yeah.
Is it accidental death on the job, or is it like they could, let's say somebody's swimming and they accidentally drown?
it's-
So it would be on the job?
yeah,
Yeah, and that's,
like getting shot.
Okay.
Yeah, could be that, or
that's
as
why I asked.
Senator
That
Carson.
needs to be all teased out.
All right, we'll go back to 337 then,
Okay.
because the amendment is here. So this was, this amendment that I'm presenting to you came from work that I did with Director Courtney and with Attorney Osterhout after we had the hearing. Senator Carson, myself, and Representative McGuire sat down with Director Courtney and had a discussion about the concerns that occurred and during the hearing, and we sort of teased out the details as to, you know, why they came in so late from with the concerns raised by OPLC did, and what had occurred was the Department of Justice weighed in after the House passed their version, and they weighed in with concerns that they sent to Attorney Osterhout, and that's why there was the late concerns raised on this when it got to us.
I see.
And OPLC certainly is committed to, you know, full transparency and public disclosure as much as they can. Their concern was related around sensitive information that could be in some of these case files that are going before the boards. And Director Courtney brought an example of one case file going before, I believe it was the nursing board, is that correct, the one she brought?
What?
One of the case files that was going before the nursing board, I kid you not, it was 500 pages. It was a binder this thick, and that was one case. So that was their concern. So I worked with OPLC, and they made some changes to the language, which are in the amendment here. And for the life of me, I'm trying to remember what they are. I wish she was still here.
I'm doing my bylaw here, counsel professionally.
Because it did it as a replace all, and I don't want to.
It's the 7 and 14 days, right?
14 days. Oh, there's 14.
Yes, and there's a little bit of language change too, and I do apologize to the committee that I am not a little bit more prepared for this. I honestly forgot about it. So I'll give you a minute to review it.
Mr. Chair, I'm looking on page 2 that it does add a new position, the Attorney 2 position, which is one of the things that was discussed, that it was taken out of at the House, and then we're putting it back in because they wanted it.
So this will go to finance to have a discussion about it, unless he waives it. I can't believe that we would, because it will make an appropriation approximately $100,000 a year for a position.
Chair, I did have one question about the language.
Yes.
And it might just be, might be addressed in another way, but on lines 17 and 18 of the amendment,
the new amendment.
The one that Senator Pearl just handed out, 1686, yeah. That sentence starts, if it is not practical to make available to the public at least one day prior, paper copies of governmental records shall be made available at the meeting location upon request, comma, provided the governmental records to be considered have undergone legal review to identify information exempt from disclosure. So my procedural question is just, if those records have not undergone legal review to identify information exempt from disclosure on the day of the meeting, do we want to just add language to the effect of, in which case they'll be provided within
That is their standard practice.
3 days or 7 days?
That they're
or-
provided as soon as possible after the meeting.
Okay,
I don't know what the day is, and I don't recall exactly what the day was, but that is their standard practice already.
okay.
And this was trying to dealing with the issue of pre-notification, making those documents available.
Yeah.
And this, there was one other thing, this also did put in a provision for an emergency meeting. I'm trying to remember where it is.
19.
Okay,
It's right
It's
down
at
right
the
on
end
19,
there.
yes, there
Yeah.
we go. It's coming back to me now.
It doesn't apply to emergency.
I do know that this language has been vetted through the Department of Justice as well, and they are okay with it. So I will add that in.
And what's the Department of Justice's interest in this?
Only in the sense that they're making sure that, that public information, or private information remains private, yes.
Yeah, okay.
From the 91A perspective. They don't typically weigh in, and that's why this kind of came at OPLC at the last minute as a surprise, because all of a sudden they did.
Yes.
So in the space you were just talking about?
Yes.
The emergency meetings?
Yes.
After an emergency meeting has been held, is the redacted information available afterwards? Like, can people request that?
It is
Can they
my,
FOIA they can
it is
FOIA
my
that?
understanding that it is, but I would want to confirm that answer with OPLC, because I believe that emergency meetings are just as public as the other. It's just that they are not having the
Right.
Notification.
Go around the
process.
other
Yes.
end.
That, if I find out differently, I will ask that question, I will let the board know, but it's my understanding that is the way it works. Representative McGuire, did you have anything that you wanted to add here? I know you were involved in the meeting, I'd like to give you the opportunity if you do. Could I have you come up to the mic, please?
Thank you. I agree that we want to be able to redact that kind of data, and I don't have too much trouble with them getting someone on board to do that. But I think I agree with the senators that we ought to explicitly say that the stuff that is not redacted at the time of the meeting or something from an emergency meeting is available within, I don't know, give them a week. I do think that would be an important point to add, that you should give them a limit, since we're doing all this.
Okay, thank you.
We're being so explicit on it.
Senator Carson.
Thank you, Mr. Chair. I agree with Representative McGuire, especially since we're going to be hiring someone. So there's really no excuse for not getting it done within a week.
Right.
So, 7 business days or 7 calendar days?
7 calendar days is what, I'd say let's stay consistent with other language in the bill, which seems to be calendar days.
Okay.
So what would you propose?
That's a committee amendment we're gonna do, right?
We can add,
Or
yeah,
add
we
it to
can
the,
make a
we're
committee
just gonna add,
change.
we're not gonna have to rewrite.
Nope, we can make a committee change to this amendment.
It would probably belong to, it would probably be between Roman 7 and 8, because you're adding a new requirement. And it applies both to the stuff that hasn't gone through review and also the emergency meetings in 7. So you'd want to create a new Roman number there.
Mr. Chair, if I might, I would be concerned about getting the language correct rather than trying to do it on the fly here. So I would rather that we contact OPLC and get the right language,
I can come back with another
and
amendment
then come
next week.
back, yeah, come
Okay.
back with another
I'm willing to
amendment.
do that.
Except that this would have to go to finance, I imagine.
Yeah,
so-
so I'll have to get it out next week.
Okay.
Yeah,
Yep, we've got
that's our
another
Our
deadline.
schedule's okay.
Yeah,
So, but we're good with, on line, so the addition is on line 18 through 21, starting with this section shall not apply to emergency meetings, blah, 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 blah. And at the end of that, adding a sentence,
Yeah, you-
governmental records shall be made, governmental records used in said emergency meetings shall be available to the public
I
within
think that
7
was
days.
Representative McGuire's
Yeah.
point, is it applies to more than one spot.
But we, what I'm getting at is that this language is repeated. Like it's repeated again on 30, so if we added that line, can you not just repeat it over and over, like as part of that packet?
We could, or we could just make a new section.
Oh,
So
right.
let me
6 to
confer.
1, half a dozen or another.
Yeah, let me confer with OPLC and see which would be better, more clear for them.
Okay.
So we're just concerned about availability of info to the public within 7 days.
Yeah, in the case of all the excuses that are in the bill.
I may not word it quite like that.
Well, I mean, exemptions, I believe, is the more technical
Yes,
term.
True. That is true. Yeah, I think, Mr. Chair, that's the appropriate thing.
Okay.
Because if you look at section 6, it is quite extensive. And we want to make sure we get the language correct, so. I think Mr. Thompson has a question.
Did you? Come on up. Yeah.
Thank you, Mr. Chairman, members of the committee. Simon Thompson, Sheen Finney Capital Group. I have, last I counted, 5 clients that are regulated under OPLC. So while you're going to go back to OPLC and ask a couple questions, if I can go to a point, not a point, but an area that Senator Cuoco brought up on line 17 and 18. And totally understand if there's a last minute agenda item that's very important that needs to be discussed, we get that. But provided the governmental records to be considered have undergone legal review to identify information exempt from disclosure, and again, we get that. If that process hasn't been done by OPLC in a public meeting that's happening the next day, they haven't done this review to make sure it's exempt from disclosure, how can it then be discussed at that public meeting?
I think they would go into non-public section if they felt there was sensitive information. That's what I believe would happen.
Okay. Because the concern is we just don't start using that line as, well, we didn't get a chance to review
Right.
this for disclosure.
No, I
Oh, we didn't-
understand.
yeah.
I understand. And I think OPLC greatly understands that as well.
And I, just for the record, OPLC did reach out to me and with a lot of this amendment, and I appreciate that.
Yeah, okay.
Thank you.
You're very welcome. All right, I think I have notes enough on this to get to where you want to.
Okay.
Anything else that anybody wants to bring up before we go adjourn here? I don't have any other bills.
Wait, is that, really?
Yeah, I think that's it.
Oh my goodness. Where was you? Just did 3:37.
No business. Do you want to discuss any of the changes we heard on 532? I know I'm planning to basically implement what we heard in terms of further concerns, but.
If you'd like to, we've got a couple of minutes. We will be meeting for exec session next Wednesday at 9 a.m. where we'll hash all this out. And we do need to exec anything with a fiscal note next week.
There's nothing I necessarily need to discuss. I just didn't know if anyone had questions, I guess. Are we expecting any further amendments to 532?
Yes, actually, there's one I forgot to bring up. Thank you.
Well, since you said something, yeah.
Since you did. I meant to bring this up when Director Courtney was here, and I neglected to. So this is the, she brought the social work licensure compact to me 3 weeks ago. And it is one that they have agreed. Carol, I don't know if, excuse me, Representative McGuire, I don't know if you have seen this either. I'm not certain if she's brought it to your attention. But
We had the social work compact was presented as an amendment to a bill that we had in House ED&A. We had a hearing on it, and we haven't yet exec on it.
Okay.
So since the language of a compact has to be the same, you only need one bill going forward. So if you decide that you really want to get the compact going this year, then you can add it on to whatever
So there's
your
some-
rules will allow.
Sure, so there's some benefits to having it go in this year, because if you're one of the first 7 states to ratify it, you get a seat at the
Yeah,
table for
well,
a lot of the
I think
rulemaking.
I don't believe anybody's ratified it.
Right.
So there's, next
Yeah.
January may not be too late.
And I don't disagree with that either, but that was one thing that I had wanted to bring up and discuss with the board. Committee.
It has had a public hearing in the House, and we're considering it along with all the other stuff that we've got and our Senate bills.
Okay.
So I don't know if we're going to recommend passing it or not. But it's one of those giant yes or no's.
Yes.
That I'm opposed to.
Yep. All right, thank you. So this compact has been agreed to, I don't remember the amount of states, but it's significant, 30 or more states that have agreed to it? Who are,
No states have agreed.
excuse me, 30 or more states that were there working on it.
Considering.
Considering. There you go.
I don't believe any of them have actually approved it as of the hearing we had. It was brand new.
Yes, but they passed it out of the compact work session.
Right. That it came out of the compact organization right around the time of crossover.
Yes. So that was presented to me if we had any interest in putting that language onto a bill. My thought was it would be pretty appropriate to the stuff that we're already working on, since it has to do with licensure compacts and things of that nature.
Yeah, I would like to do that. I've heard from a couple of folks since we discussed that that would be helpful.
And I do have a copy of it if anybody actually has time and interest in reading it, which I do not.
And then I guess my last question, Chair, is there was some language related to OPLC that had been in HB2. Are we expecting any of that language and just part of this process to come back to 532?
There's nothing
or
that I
otherwise?
have right now that I have the bandwidth to even look at and move forward.
Okay.
So if the rest of you do, you are, I don't know, Senator Carson, do you have any input on that?
Mm-mm.
Okay.
Okay, and there's nothing under, I'm actually getting, it's more constituent concerns about some of the boards that were combined in the original language. So if that's not coming back, I can tell them to rest assured at the moment.
Representative McGuire? Come on back up.
That's exactly the case. I'm expecting to have bills for next year whereby doing some of the advisory boards that we took out of House Bill 2 and possibly some of the board combinations. But the stuff that's left in House Bill 2 will probably stay there. The House ED&A Committee is working explicitly on LNA licensing and the Board of Mental Health, the mental health boards, the combination and their statutes and stuff like that. Those two issues we're working on, and we expect to attach them to some of our retained bills.
At this point, the only intent I have in changing anything in HB2 is removing one phrase related to the electricians. I've put an amendment in for that. And
The other thing is that I know of is the Assessing Standards Board, which should not be moved to OPLC. That's a deletion from House Bill 2, which is pretty easy to handle.
Okay. All right.
Okay, thank
Thank
you
you.
for discussing.
I guess that gives you the clarity you need, maybe?
Yep. Clear as mud, right? No,
Right.
I'm just kidding. I follow you. Thank you very much.
Further discussion from the board, or are we? everybody's
Monster
good?
I was just wondering, Chair, if, right now I'm scheduled to land on a flight at 9 a.m. next Wednesday, because I thought we'd be done by now. So I didn't know if you thought we could meet at 10:30 next week, so I can make my way up here, or if I should move my flight, which I can do.
I will tell you, I had to do some arm twisting to get the calendar held until noon.
Yeah, okay. Be easier for you if we met earlier than later.
It would be, if that's possible on your end.
I will do my best.
All right. Anything else? I'll accept the motion to come out of exec.
So moved.
We have a second?
Second.
Moved and seconded. All in favor?
Aye.
Aye. And since I believe our work is done for the day, we are adjourned.